Welcome to Blue Dirt, the podcast that digs deep into the foundation of commercial real estate investing. Unlike most real estate shows that focus on deal making and market trends, Blue Dirt gets into the nuts and bolts of what truly builds long-term value, the building itself. We break down how to spot deferred maintenance before it costs you, why a solid preventative maintenance program is a game changer, and how triple net leases can maximize your investment returns. We'll also explore the importance of strong landlord-tenant relationships and how they drive stability and growth in your portfolio. Whether you're a seasoned investor or just getting started, Blue Dirt gives you the practical knowledge to make smarter, more profitable decisions in commercial real estate. It's time to get your hands dirty and build value from the ground up. Let's dig in. Welcome to Blue Dirt, where even idiots can make a killing in commercial real estate. This is Don Redhead. I'm Michael Caro, and Don, introduce our guest today.
Yeah, this is Tim Baldwin with PMLS, or Property Management Law Solutions, here in Pensacola, Florida. He does a lot of work with us, so I was very generous and actually went on Tim's podcast while you were in Europe. So now Tim is returning the favor.
That's right. Well, welcome, Tim. We're excited to have you. I got a lot of questions, and I was trying to think about the format in which I wanted to ask the questions, because there's, as a landlord, so this is probably more of a landlord show from that perspective, because the areas that I would like to touch on, Tim, are what can a landlord do in advance of even signing a lease to make sure that they are properly protected, and then through the stages of a difficult situation with a tenant, there is a process that we've gone through, because we only do commercial real estate. A lot of times when a tenant is having difficulty, they want to get out, so it makes it easy. But sometimes you have a challenge where they don't want to get out, and that's where a process comes in. So I want to touch on that process. And then I want to touch on options that a landlord can go through to possibly recover some of the lost revenue that the tenant may have caused. And of course, in the state of Florida, they have different laws than other states. So we might be able to touch on some of those, like acceleration and landlord's obligation to mitigate losses.
Yep.
So does that seem like a good format for this morning?
Yeah, that's a mouthful, actually, Mike.
All right. Well, we can also break it down into two podcasts if we need to.
Yeah.
Maybe.
All right. So let's talk about in advance. A property owner owns a property. They want to lease it out to a tenant. Let's just stop there. From your advice, what should the landlord do to properly prepare themselves for signing a lease with a tenant?
Well, there's several things. Probably I'll just mention at first, they need to have a great lease agreement. That is like your operation document. That is how you enforce your the tenant obligations. It's how you can prevail in a legal matter. So the lease agreement is just vitally important. The other thing really is a question to ask is, are you able to manage this property yourself? If not, then you need to hire a qualified property management company to do that. The other thing is you have to consider risk of liability on the property itself. So you need to look at the property, make sure that it's doesn't have any hazards and these things that can expose you to liability.
Okay.
The other is make sure you have proper insurance coverage. So liability insurance coverage at a minimum, but there's other policies that can help protect you as well, like umbrella policy and these types of things. So those are four big topics that a landlord has to go through before they get that tenant in that property.
Great. So let's talk about the lease first, since that's what you brought up. So, obviously there's a lot of leases out there. You can even go as a landlord to lawdepot.com, type in your state, the type of lease, and it'll spit something out for you. There are leases that I've had other attorneys draft for a certain tenant situation. And then a lot of times I simply wash, rinse, repeat those.
Yep.
And so, but within the lease structure, there's a lot of things in there, but what are some highlight areas in which a landlord really needs to lean into and make sure that they have the right language?
Well, for a commercial lease, there are a lot of topics. Quite frankly, it's but really it's like the big ones are like, what are your maintenance obligations? Defining the rent payment itself. So are we including taxes, insurance, incidentals? Like, what are we covering? So those are two big ones. But there are many others, like you mentioned, even acceleration when you're dealing with a default tenant.
Slow down.
Yeah.
We're going to make this a dialogue.
Sure.
So let's talk
Tim's
about.
very passionate.
I am very passionate
Let's
about
talk about the, and I agree that the one thing that I always highlight with my tenants, and I really slow it down, even, oh no, I've got it, we've read it.
Yeah.
Okay, but let's go through, and I want to, and I bring them straight to the maintenance section.
Yep.
Because to me, that's the most important thing for them to truly understand, even though they're ready, even though most of them say, oh, I've had my attorney review it. Whether that's true or not is up to them.
Yep.
But I slow them down because it's really important to me that they understand what their real obligations are. And in our leases, because we do the triple net leases, the landlord is responsible for the roof and envelope and structure of the building, which is how we operate our leases. And then the tenant is really responsible pretty much for everything else. And of course, there's a lot of pushes and pulls on that, but by and large, that's how the leases are structured. So what have you seen, and where do you see landlords fall short in that section?
Well, if the lease language isn't drafted well enough, if there's some vagueness to it, some ambiguity to it, which then leaves the question of whose obligation is it. So it needs to be properly defined. So when you're talking about, is it inside the walls? Is it above the ceiling? Is it outside, exterior? Or even if it's within the unit itself, are there certain aspects that still could be a landlord's obligation based on the type of event that occurred? So, for example, there could be a water leak. Maybe it came from the ceiling. Maybe it came from behind the walls, but now it affects the inside. So you have to address those contingencies, if you will. So really, it's just getting to the granular and try to, the provision needs to have as much comprehensiveness to it as possible. There could be gray areas in reality, but you have to do your best.
Is there a catch-all sentence at the bottom of that section that says, everything not related to roof structure is the tenant responsibility?
Yes.
So
you can.
Yeah.
Yeah.
So we're in the process, you talked about having our template and then modifying it. And as I shared with you, we're going through right now a review of the lease to add a lot more language from an operations side of things from our property management team. And then we're going to send it over to your team for review. So we're in the middle of that process. And one thing that we've just added was basically outlined all of these things. But then at the end was the catch-all sentence was any and all associated costs with the ongoing operation of this property. So it's kind of this, if it has any cost associated with the operation of that facility, it was trying to catch everything in that one sentence.
Yeah, you can define these things as community associate or community fees or management fees, but if it's not actually a community where there's shared obligations from different tenants, then it's isolated to that one tenant. Yeah, you can. The good thing about commercial leases is basically you can define whatever it is that the parties want to do. So you mentioned operation. I mean, maybe you can clarify that a little bit when you're talking about operations for those who are listening. What's the difference between an incidental incidents, rain leak or plumbing leak or whatever versus an operation expense?
There's not at all.
Well, I would disagree. In the example I gave, there is a distinction between a roof leak and a condensation leak that's inside the ceiling. Obviously, one is an HVAC caused event, which in my world, the tenant is responsible for that. If it was a roof leak that came through and then stained ceiling tiles, maybe damaged something, then I might look at that as a landlord expense, not just to repair the roof, but also the ceiling tiles and such.
So that's a great point, because then you begin to distinguish a natural event such as rain, wind, flood, fire versus not a non-natural event. So something that's created by a machine or by the tenant themselves, by a guest, by a visitor, whatever, that sort of thing.
Right. Well, because if you think about it, an air conditioning condensation leak, which happens all the time, is typically caused because of something, maybe a lack of a balance, or maybe humidity condition. Don, you know this area better than I do.
Typically, it's because of a tenant modification to the space. Typically, I'm going to say once again, typically, if we turn over a space,
hold on,
it's
can you say typically one more time, please?
There's typically a situation that could happen. Is if they're moving in and it's operating as normal, it's our issues usually happen as a result of them adding some walls, doing some modification, maybe the intensity of what they're doing there. There was one that I was down at the city talking to them. There was a lawsuit they had that they brought in a lot of extra power and it changed the heat load in this facility and started adding condensation and all these things going on. But typically, it's because of a modification to the space.
Yeah.
See, now, whenever he says that word, he's going to
think about it.
I'm going to love it.
It's going to throw him off today.
Where's a button that we can?
I'm going to start firing off emails. Typically.
Well,
where's a button?
But the point, what you're describing are essentially that there are nuances in the commercial landlord-tenant relationship. They have to be defined. You get into these gray areas, and then that's when you have the disagreements and contention, and you're trying to avoid all that. So as best as you can define these obligations in the lease agreement, to your question, Mike, you need to get those in writing at first and get your lease prepared.
Yeah. All right. So landlords, don't go cheap on the lease. Even if you use a template, get a really good template from a great attorney who understands this, not just a real estate attorney, because what I have learned is a real estate attorney can draft a great lease, but who should review the lease is somebody who actually has to litigate that lease. They're the ones who can actually determine where the chinks in the armor are because they're the ones having to defend it. And I apologize, Tim, do you go into lawsuits like this?
Oh, yes.
Okay. So somebody like Tim would be the guy that can go in and really pin test that lease to make sure to see where the weaknesses are.
Yep.
When someone comes to you, what do you think kind of ballpark ones that you do have to litigate are landlords that didn't use an attorney review?
Well, yeah, because typically if there's not a lease, and it's really not even just a real estate.
Word. What was that word?
Typically, when it's not, and it's not just whether it's prepared by a real estate attorney or not. As you just said, it's someone who's specialized sort of in is where are the holes, where are the gaps, where do we need to fill in the blanks here? But the ones who don't use those types of leases, in my experience, I've been doing this for 21 years, there's always going to be holes. There's always going to be some issue, some topic, something that wasn't addressed, wasn't even contemplated. And that's just ripe for litigation.
But I mean,
listen,
just an example.
COVID, threw away all these leases as to something that was never contemplated.
Yeah,
and post-COVID, we have added all this new language to the lease, or at least we're having a lot of tenants want to say, because listen, when it's beyond the tenant's control, which is also beyond the landlord's control, that's what incorporated into a lot of new leases post-COVID.
That's just right on that. So during the COVID era, there were several cases that came out on the issue of the tenant's obligation to pay rent or not.
Right.
And so the courts analyzed these and addressed these leases and really dug down deep into, did the lease anticipate that the tenant could terminate, relieve their obligation in this sort of event? And the results were that many of these leases simply did not.
Right. Now, in all fairness, what Don and I did with especially our restaurant tenants is we didn't wait for them to call us. We called them. First of all, I called all of our lenders. I got my lenders on board to go down to the lowest possible rate that I could pay as the property owner. Then with that information, I went straight to my tenants and was able to reduce I didn't go to free, but in many cases, if their lease rate was, let's say, $10,000 a month, I was able to get them down to $2,000 a month. Didn't ask for anything in return. It was a time where we all are suffering, but how do we just get through this period of time? And so, you can do things that it just makes common sense, being a good landlord-tenant relationship for the long term.
Yep, absolutely. Sorry to interrupt you, Don. You were going to say something. You probably
I'm sure he's already forgotten. His brain span is like this. It's unbelievable.
No, but I was curious. Yeah, with you getting these probably individuals obviously contacting you post situation, right? Yeah. What kind of percentage of people are just coming with a homemade lease?
Well,
that they've just
written on a napkin.
Essentially not maybe not that bad, but one that they, ChatGPT to quick lease ran out the door, and probably ChatGPT is probably too new. But what do you typically see?
No, I mean, it's that. It could be that, or it could just be a template downloaded from some obscure website or whatever, or just an old lease that they've used for the past 20 years. We see those all the time. And again, I just can't stress this enough that is so critically important. I mean, but here's the thing about that I see a lot of is that the contention many times comes from just lack of communication in the first place. So a move-in date or a commencement date, or, hey, we have construction going on. When is this construction going to be completed?
I have failed in that category where we know the first date that we invoice them, but the lease does not reflect it.
Yes.
It says it might be a 5-year lease, and we know it's supposed to start when the construction is over, but we didn't create that addendum that says, okay, the lease officially started, and getting both sides to sign it.
Right.
And so, I've had a recent incident where the tenant that I originally did the deal with sold their business, and the new owner, there's like, hey, we're leaving at the end of X month. And I said, well, no, the lease goes through the end of that. He goes, no, that's not what the lease says. Well, and they were absolutely correct. We did not go back and have them. Now, so it turned out instead of being a 60-month lease, it was a 54-month lease. And so, but that's shame on landlord, right? And I think the law is always going to probably favor the tenant.
Commercial is not as much that way because the courts see both parties typically as a arm's length transaction, as compared to residential, where it's an adhesion contract, we call it, where it's either you sign it or you don't. They're gonna, but still, even that though, the courts can tend to favor tenants to some extent.
Yeah.
So.
Okay.
Yes. But going back to what you're saying, Mike, is that every commercial property is a little different, and the circumstances around that property are different. And so your lease many times needs special addenda to address the specifics. I mean, even going to construction, sometimes that's within your control, sometimes it's not. And then we talk about, let's just say the tenant's waiting to move in. If it's a restaurant, for example, hey, I really need to be in business within 3 months. And so they're expecting you to have the doors open in that 3-month period. Well, there could be things that COVID, for example, or just the market changes and we can't get the construction done in time, or they can't get the construction done in time. So when have we then breached our sort of due diligence, our reasonable diligence period, all those issues. So like having these definitions about, hey, we're not liable for third party, actions or inactions and these types of things helps to offset your liability in those situations.
Yeah, one thing we were dealing with right now that you're talking about, kind of that maintenance gray area, and the tenant fortunately is really good, so we're able to work together. But is that, in the commercial lease? Are
you talking about me, by the way?
No. We're only just begun.
Okay. All right.
We've only just begun.
Is a restaurant tenant, and the previous tenant had done a lot of things that altered the infrastructure of the mechanical, the electrical, and plumbing. The tenant is accepting the space in good working order, but now as we're peeling back the layers of the onion, he actually didn't do the plumbing to code. He didn't do the electrical to code.
Yeah.
So now the landlord fortunately understands that they need to step in.
Yeah.
And they are spending some big money, but it's one of those things that, some landlords could be like, no, this is just turned over and this is fine, right? So it does need both parties to work together, right?
Yeah. Well, you mentioned if the previous is a great issue that we can flesh out a little bit, but when a previous tenant has done something to the property that then makes it in some ways either not rentable or less valuable, or you have to expend monies to fix what they've done, then that's another situation where the lease needs to address that. So you can actually go back to that previous tenant and say, hey, you've caused this damage. This is what you've done. This is our demand. You may not get paid right away, but you can.
I think in this scenario, we won't get paid at all because you guys have already squeezed all the blood out of that turnip.
Oh boy!
So from a different situation,
I can't wait to learn which one this is.
Yeah, I bet you have no idea.
Is it one that I own?
No.
Okay, good.
It's not. It's not.
So I'm not the landlord in that situation.
No, you're not.
Oh, okay.
No. We put a little red flag by the ones that you.
But
own.
you've. The tenant basically can barely meet the obligation of the past due rents, let alone adding this these layers.
Right. Well, that goes into security deposits, right? How much should we require? And then how do we go through the steps of getting it? Are there insurance policies that help to cover for tenant damage? There are insurance policies out there. So that's another issue. Does the landlord need to find the right policy?
See, and this is the balance that I have as a landlord, and that is my focus is how can I keep the pass-through expenses to my tenants, even though they're the ones financially obligated to pay it? How do I keep them low enough to where they can be successful? I can insure the heck out of everything and cover every possible scenario, put that expense on the tenant, but it makes them less likely to succeed. And yes, while I might be covered, would I want to pay for that if I was the tenant? And if the answer is no, then I try my best not to do something like that to my tenants. Because I can't stand insurance. Yes, I understand it's a necessary evil. And of course, everything we have is insured. But this extra insurance is just too much for our tenants to bear, at least most of them.
Especially fortunately, the market is softening, right?
Well, you're talking about wind, but he's talking about so many other different types of policies.
Correct. I'm just talking about the bottom line, though, right? Fortunately, our insurance rate because of wind is going down. So in the aggregate, yeah, I am talking about something different, but I'm talking about the true total cost of all the insurance, and that's just a huge piece of it. Yeah. So, but they have to cover.
Well, it's like where there's not insurance coverage, somebody is bearing the loss. Somebody is
bearing the risk, right? Yeah. Absolutely.
Yeah, no, that's fair.
When it goes back to the quality of the tenant, right? We have tenants that the quality is very high. If they're a smaller company, we have them sign personal guarantees, which, by the way, how do those shake out?
I just struck through mine that you guys sent me, by the way. No, just kidding. No, the personal guarantees are a big part of the commercial lease agreement because, the LLC may be a startup or whatever, just may not be solvent.
Correct.
So those personal guarantees are pretty important, just like the cases we're handling for you guys right now, where there's personal guarantees. We named them. They're in the suit. They get ticked off the fact that they're in this position, but hey, that's why you signed it. I mean, you're there to guarantee. But the
quality of the personal guarantees that we provide to our tenants, and then if there is a situation, are those all, from your perspective, good and enforceable?
Yes.
Okay. And so let's talk about that. When you're signing a new lease, most LLCs that somebody has, especially newer ones, or even if an LLC is 10 years old, it may not have any real assets, right? And without substantial assets, we require a personal guarantee because here's what can happen. I can have an LLC. I could be worth a boatload of money, but only the LLC is on the lease. If I don't want to be in that property anymore, I could simply have that LLC cease to exist, or it can still exist and I just dwindle it down to zero. That landlord's going to come after the LLC, not me, but the LLC, and the LLC is nothing.
Yep.
Correct?
Correct.
So without me personally guaranteeing it, you really don't have any weight, And let me tell you, all the LLCs that I care about are multi-facility LLCs. So if you've got a restaurant group that has 10 restaurants, and that LLC operates all 10 restaurants, and you got to be careful because there might be restaurant number 1 LLC, restaurant number 2, all the same name. Yeah. I'm not talking about names. I'm talking about the LLC has to be the same, and you have to see the balance sheets and everything before I will accept just that LLC. Otherwise, you're at way too high of a risk, and really, I think you have a month-to-month lease.
Well, the lease will determine whether you have a month-to-month lease or not. But no, you're exactly right, though. I mean, the entity is specific to its registration in this division of corporations in the state of Florida, which most states have that sort of thing. So, yeah, you've got to look at that. And as you say, I mean, most LLCs, a lot of LLCs or companies in general, really don't own assets.
Right. And that's by design. Right. So personal guarantee, it's an exhibit at the end of your lease. Even if the lease is only in the LLC name, there has to be a personal guarantee exhibit and get them to sign and notarize that.
Well, by the way, there could be other things as well, Mike, that you can do even in the middle of the lease. Okay. Let's just say the tenant wants to do something, major renovations, whatever, and potentially the renovation or the what am I looking for? The remediation of what you've got to do to bring it back to whatever the rentable condition is could be substantial. So you say, hey, look, this is, we need some security from you that you're going to do all this, and this is going to probably be the cost to us. So let's get something to secure that risk for us.
Well, you bring that up. I've done a couple of leases where the tenant had a specific build out. And so there's a couple different ways we've operated. So let's just pick a number. The lease rate is $15 a square foot, kind of as is. It's in good condition. Everything's fine. But they want us to add so much money to make it unique to them. I typically have two choices, but one of the options, well, the first easy choice is I kind of add it all up. What am I going to spend? Amortize that over the course of the lease. Maybe it's a 5-year lease. Maybe I even have an interest rate attached to it. And then I gross it up from $15 to, let's say, $18 a square foot, whatever it is. Tenant says, yeah, that's great. They didn't have to put their own money in. But I've also done other things where I keep the rate at $15 a square foot. I have them sign a promissory note instead. So they're still paying $15 a square foot, but they're paying a lease, actually more like a mortgage payment. What would you call that?
It's just to amortize
a loan.
Yeah, a loan.
So they make a loan payment. So at the end of 5 years in this example, that loan payment is paid off and their lease is not so high. So it is a way, especially for where you have a very long-term lease planned, even though it might be a 5-year lease with 3 or 4 5-year options to renew. So you know they want to be there long-term, but they don't want that because in many cases, you start off at $18. After 5 years, a lot of times it doesn't drop back down. It just continues to rise.
Well, there's a lot of issues with that too, because if you're spending $1 million as a landlord to build out specific for that tenant, there's the expectation that they're going to be there for that full term. But what if they're not? What if they breach early? They leave. They stop paying rent. So what are your damages? So having even either a liquidated damages clause or an acceleration clause to help at least give you the ability to go after them to recover those lost monies, because many times it could be a great expense on the landlord.
Okay, I don't think I have a liquidated damages clause in our lease, do we?
I don't think so.
You can do liquidated damages, or you can do an actual damages calculation. So whatever it is they have left on the lease.
Are you reviewing my lease right now?
Are we reviewing your lease?
We're 50% of the way.
Yeah, I think we're going to here in the near future.
Hold on. Are we 50% of the way through reviewing the lease?
Like I said in the beginning of the conversation, the operations team, the property management team is 50% of the way through modifying our current lease template. Once we're all the way through, because we may throw some random stuff in there that isn't technically legal. So that's why we're sending it to you to review.
I don't believe it.
I don't know. I mean, we may have some crazy ideas out there.
If they don't pay, you cut off their hand.
Well,
I thought a thumb.
Thumb. That might be better.
I want to start saying,
yeah, we'll check that one out.
It depends on the lease rate.
Well, maybe the pinky, because that way they can still work. The opposable thumb is a hard thing.
Maybe we have to specify that. What kind of industrial tenant is this?
I think you're going to flag this podcast as somewhat, what do you call it? Sensitive.
Explicit.
Explicit.
Is that what it is?
No, you're saying. Remember the tagline, idiots can make a killing in commercial real estate.
Yes.
So.
But we still need to send it to the attorney to verify.
Well, I mean, I'm glad you're going to do that. It's good.
Well, because like I said, we may actually say, hey, this is yours, and you're going to come in and say, no, you can't do that because of whatever statute. And then just nix it. But from an operating standpoint, it's how we're seeing it unfold and issues that we're having to deal with. We're just trying to mitigate those.
Right.
And have a good relationship so it's all crystal clear, more information that we can all, operate in a good world, because we're here to help.
Yeah.
But if it's unclear, like you said, the gray area, that's where the confrontation in our minds comes from.
So let me address Mike's attention to the liquidated damages provision. So liquidated damages are, simply that, hey, you didn't fulfill your lease, you owe us X amount, and it's a predetermined amount, and the courts enforce those. As opposed to, hey, you have 5 years left on your lease, and so you owe all of that money until such time as we're able to re-rent the property on your account. So that's also an option, which is not a bad option. Again, in both of these scenarios, not the acceleration. It's just simply that
acceleration is horrible, and I think it's completely unfair to a tenant in the case of like Alabama.
Okay.
So, are you familiar with this? How it works in Alabama?
I'm not particularly.
So, in the state of Florida, and you need to correct me if I'm wrong. In the state of Florida, the landlord has the obligation to help mitigate the losses of a tenant. So, if a tenant signs a 5-year lease, if they move out after 1 year, the landlord has to show good faith that they're going to try to lease it up and help stop the losses of that tenant. Good so far?
Right.
Okay. And let's say it takes 6 months to find a replacement tenant that's acceptable, paying the exact same rate. Then that tenant was only obligated to pay 6 months, and then they can be let off.
Correct.
Okay. Alabama, and then they owe nothing after that. So they actually paid 18 months in this 5-year lease and were let scot-free. Alabama has what's called an acceleration clause, but it's a double dipper for the landlord, which I believe is completely unfair to the tenant. Same example, tenant signs a 5-year lease, leaves after 1 year. The landlord can immediately file acceleration for them to pay the remaining 4 years of that lease, the entire 4 years. Even if the landlord finds a tenant after 6 months, i.e. 18 months into the lease, that previous tenant still has to pay for the entire 48 months. And so the landlord now got double the money for 18 months on, which I think is completely unreasonable and unrealistic.
Yeah, Florida of course aren't going to do that. Even if you had an acceleration clause,
right,
and you were to go to court, what they're going to do is they're going to say, look, I don't know when you're going to re-rent this property, so I'm not going to order them to pay you 6, 7 months or a year down the road because you may rent it next month.
Right.
So that's typically, in fact, there's a recent case that just came out that said that very thing. So,
and that's why we don't file any claim against a tenant until we release it, because otherwise you literally could file a claim every month, right? Which is we don't want to do that.
Sure.
If it takes us 3 months, takes us 6 months, takes us a year, we're going to be patient until it gets released. And then we'll go to somebody like Tim and have him, go for the judgment against.
Now there is a disadvantage to that though.
Okay.
And that is sometimes time is of the essence.
Okay.
So again, if you're dealing with LLCs or personal guarantees, if you wait a year down the road, who knows what their situation may be? Who knows that the personal guarantee will even be alive? So it can be strategically a good idea. You may not want to, file the very next month. You might wait 3, 4, 6 months, even a year maybe. But again, time is of the essence. And typically time delay helps the defendant, the tenant in this situation. So something to keep in mind.
And correct me if I'm wrong, I think there's a couple landlords that we've represented that have wanted to start pursuing it earlier, right? We haven't fully leased out, leased out the space yet.
Yeah.
And they want to pursue action, and we can get correct me where I'm wrong, we can get the judgment against and have them rule in our favor.
Correct.
And then for what has been lost up till this point.
Correct.
And then once it's been released, there's already been a judgment.
Correct.
In our favor, and it's a simple.
So you supplement the judgment. So you say, Your Honor, we got our final judgment. This is what our damages were at the time. 6 months have passed, and we have these additional damages. We finally released it. So here's our additional damages.
So that's okay. Now that's something I had no idea about. So, but kind of all threads together. So if you said, "Hey, listen, maybe 3 to 4 months later, go ahead and file, get that claim,
right,
or get that
judgment, try to get a judgment,
and then if it takes another 4 months, and then you finally release it, so then at that point, the updated judgment is a more simple process."
Yes. Yes.
That's worth today's podcast right there.
Well, I'll tell you this as well. Here's what helps as well is that normally if you were to file an action for damages, let's just say 2 months down the road after they've early terminated, normally since it's so fresh in their minds, they many times, if they're able, will try to work out a resolution of some kind. Maybe they still want to be in business. Maybe they still want to rent there. I mean, who knows? So it typically will allow, to a greater extent, you working with that tenant to some degree. Or they may get an attorney and say, hey, help me resolve the situation. As opposed to waiting a year down the road. Again, they moved, they're nowhere to be found. And, and even us trying to find them to serve them with a lawsuit can be challenging at times.
Right.
So.
Fantastic.
Yeah.
What other lease clauses should we pay attention to? By the way,
that's a big question.
The signature page. Is it correct that the state of Florida no longer requires witness signatures?
Right. So you don't have to have them for leases that it used to be that if it extended beyond a year, but now that's no longer the requirement.
And then our personal guarantees, we have those notarized. Is that a good practice or not necessary?
No, I think it's great. I mean, really, it's like, why not?
Okay.
But is it neat?
It's not required.
Okay.
All right.
Yeah, you have to prove that they've agreed to it, so their signature is proof. But certainly, if they say, "Oh, that's not my signature," then a notary comes into play.
Right. Okay. What other lease clauses should we be focused on?
Well, again, that's a pretty big topic. I'm trying to think of. Oh goodness, Don helped spark my direction.
You got a lease,
here.
you got an ending, you got a renewal.
Sure. Renewals is a good one because sometimes I see this and it's a horrible idea, I think, is that automatic renewals without even regards to what the landlord may want to do with that tenancy. And so it's almost like in some instances can become a big legal issue if there's sort of this perpetual renewal option in the future. It creates a big problem.
So you're saying auto renewal.
It's not a good thing.
I would hate that as a landlord.
Yes.
I mean, I guess in some cases I wouldn't mind it, but I really want there to be an active conversation.
Correct.
I personally, on every vendor, not landlord situation, but every vendor that I sign up for, I look for the auto renewal and cross it out.
Yeah.
I can't stand auto renewal. I want that salesperson to have a conversation with me. Are you happy with my service?
Yep.
Do you want to continue? Don't trap me into auto renewal.
Did you know this? This is a little bit of the advice that you may like to hear right now on that note. If you have a auto renewed contract with the service provider, they have to give you at least 30 days notice prior to the end of that contract to say, hey, it's coming up for renewal. And
I did not know that.
And if they didn't do that, then there is no auto renewed contract. So
Really?
Go back and look to see.
When did that happen?
It's been a statute of, I don't know how long. It's been a while.
Oh, really?
I won a great case.
Because I remember
on that issue one time.
A great case.
Oh,
What's
well,
a great case?
It was a great case for my client. I won it.
Okay.
So the vendor was going after them breach of that vendor
Was it
contract.
Cintas?
I can't reveal who it was, but
oh my God, those guys, they get their claws in you and they will not let go.
Yeah.
They're ridiculous. They don't even have to show up. Like, no, we don't service that. They're like, no, you pay.
This was this company that was going after my client it was a national company, vendor service. I won't tell you that it might tip off who it is, but they were going after my client and said, well, let me see your notice to my client for auto renewal. They couldn't do it. Dismissed, gone, done.
One of my favorite was I don't think they have it in their contract anymore, but it was an elevator company.
Mm.
And it was like, you can't notify them more than maybe 90 days in advance that you want to terminate the contract. And it's like a 5-year term with these elevator groups. But it was, you can't notify them more than 90 days in advance.
And not less than like 30.
Not less than 60.
You have a window.
You have a window of 30 days to notify them. You can't notify them in advance of that.
Right.
It has to be in that window.
Right.
Now that doesn't seem legal.
Whether that would strike the conscience of the court to say this is unenforceable. Again, commercial contracts, the courts very much just follow what it is unless it's just, unconscionable.
Pay attention to your vendor contracts. Cross through anything that has auto renewal. That's a pet peeve of mine. But I do. And we're gonna have a second episode on this going outside of lease. But I did have one thing.
Yeah, put a button
that I wanted to talk about, and that goes back to the renewal. So I had a situation as a landlord that I had a desire to redevelop a property, but I had one lease in place that, they controlled, and they had a renewal coming up for another 5 years. And if they renew, then I can't rebuild the property, but it's their right.
Yep.
So I can't do anything.
Yep.
So I remember they had a renewal, let's say 90 days. They had to notify me within 90 days. And I'm like watching the clock, and so they missed the deadline. And I called my attorney on 89th the next day. And I said, hey, listen, here's the situation. They haven't notified me. If they notified me today, what is my obligation to renew their lease?
Mm-hmm.
And what would she have said?
If they did it before the notice period was
If
invoked?
they did it after it was expired.
Oh, so if it was,
They had to let me know 90 days or longer.
Right.
And this was 89 days before the expiration.
The court, again, is going to review that lease and say, I'm sorry, you missed the 90-day mark. It was clear and unambiguous.
That's what she said. And she said, but I wouldn't just reach out and, let them know.
Well, the court also looks at good faith or bad faith, right? So if he looks at you, Mike, and says, well, I think you really had something else going on. There's a bad faith motive.
Right. Well, I just had a motive of, hey, listen, I hope he doesn't renew.
Yeah.
So, and so
sounds good faith to me. Yeah.
But it's his space, right? Yeah. So then I'm saying 3 weeks before the expiration, he reaches out and says, hey, go ahead and renew that lease. I'm like, yeah, no, I'm sorry.
Go ahead.
Go ahead and do that.
We're not renewing this. Yeah. I'm actually going to shut down this property, redevelop it, and so it worked out for the way I wanted it to. But listen, I'm prepared. I'm a big boy. I signed the lease. He can be there as long as he wants, provided within the provision. So again, you have to pay attention to your notifications.
Yeah, notices in general, just as in terms of landlord-tenant law, is so very important. We've talked about this many times, Don. So your lease agreement, for example, like making sure that you're not requiring more of yourself than the law requires. For an example, let's just say that the law gives landlords, if it's a non-payment of rent, you have 3-day notice to pay. Right, that's what the law says you have to give them. I've seen some leases where it's 14, 20, whatever days to pay rent. It's like that's just a recipe for disaster. If you've got to wait that long, because that typically means if they don't pay on time, you're probably going to see this issue again next month, and it just continues to roll down the road. So you making sure your notices don't burden you more than the statute actually requires.
Yeah.
That's
well, and our leases typically have 5 days. But now that you brought up the term notice, so in the old leases, everything was, when you gave notification, it had to be in writing, it had to be return receipt, certified, all this other happy horse crap, right? Yeah. So we have now updated our leases to say email notification is acceptable.
Yes.
Is that truly an acceptable form of notification?
It is. And there's actually a Florida case that came out of Florida TCA that said email is a proper form of delivering a copy of a notice. It's interesting because that was a residential case. And then the residential landlord-tenant statute actually was amended to verify or confirm essentially that you can email notices. Although I don't like that statute, we won't get into that. But commercial, it could be defined in the lease.
Yeah. Okay. And we have further defined that. Well, folks, that wraps up this episode of the Blue Dirt Podcast, where even idiots can make a killing in commercial real estate. That's a wrap for this episode of Blue Dirt. We're here to help you build smarter, invest wiser, and create long-term value in commercial real estate, one solid foundation at a time. If you found today's insights useful, be sure to subscribe so you never miss an episode. And if you know somebody who could benefit from these discussions, share Blue Dirt with them. Got questions or topics you'd like us to cover? Reach out. We'd love to hear from you. Until next time, keep digging deep, stay sharp, and remember, real value is built from the ground up. See you on the next episode.